Hello, today is Friday, July 19th, 2024. I'm Sarah Krafasi, and this is Staying Connected. Unless you sat through an administrative law class or regularly work with administrative agencies, you likely haven't spent much time thinking about federal agencies' authority. But two recent Supreme Court decisions have thrown agency powers into the spotlight, and surprisingly, they may have an impact on enterprise customers' usage of ICT services. On today's podcast, I'm joined by my LB3 colleague, Steve Rosen, who specializes in telecom regulation. So, Steve, unlike the two of us, the words Chevron deference probably haven't meant much to our listeners until recently. Could you explain this concept to our audience?
Yeah, that's probably not a term that comes up in conversation unless there are lawyers involved. Chevron deference comes from a 1984 Supreme Court decision called Chevron USA versus the Natural Resources Defense Council that concerned ambiguity or silence in statutes. In the Chevron case, the Supreme Court ruled that where a statute is silent or ambiguous on a given issue, the court should defer to agency decisions and expertise when it comes to statutory interpretation for concepts within the agency's purview. The court found that where a statute is ambiguous, and most of them are, if an agency's interpretation is based on a permissible construction of a statute, the agency's interpretation should govern. Or, put more simply, federal agencies are best suited to make legal and policy decisions within the scope of their statutory mandate from Congress.
Got it. And yeah, that Chevron deference concept was clearly a pretty pro-agency standard, but you're right, based on the thinking that agencies are the experts in their field and are full of subject matter experts who deal with a very specific subset of the national economy. For example, for our interests, the communications industry with the FCC, day in and day out. So the thinking was that these experts in particular areas of the law and the economy really didn't need micromanaging by our federal judges who review a very wide variety of criminal and civil cases every day. So until quite recently, where an ambiguous statute was subject to dispute, the scale tended to lean toward the agency's view as to how it should be interpreted.
Until recently is right. This term, the Supreme Court overruled Chevron deference in a case called Loper-Bright Enterprises versus Raimondo. In Loper-Bright, the Supreme Court ruled that it is the judiciary's responsibility to interpret statutes and to assess whether an agency acted within the scope of its statutory authority. The court said that pursuant to the Administrative Procedure Act, which governs how U.S. administrative agencies operate and interpret their abilities and obligations as granted by Congress, judges are tasked with determining the best reading of a statute, regardless of whether an agency has offered its own opinion. And in that vein, they held that Chevron's tilt towards agency rather than judiciary statutory interpretation was inconsistent with the APA's mandate.
So this means that we won't see courts deferring to administrative agencies' interpretations of the statute so readily moving forward. But I understand that Loper-Bright is only half of the shakeup?
Correct. In another decision this term, FCC v. Jarkizi, the Supreme Court cast doubt on agencies' ability to enforce their rules through their internal administrative tribunals. This case is a bit more in the weeds, but I'll try to simplify so we can get to the punchline. In this case, the court was concerned with the place where cases are decided, called venue. Congress gave the SEC a choice of venue between federal court and its internal administrative tribunal for prosecuting fraud cases. But in this case, despite Congress's grant of a choice, the court said that fraud cases were common law in nature and must be litigated in a jury trial pursuant to the Seventh Amendment. Then the court further broadened the scope of cases that must be tried in federal district court rather than before independent agencies to include all common law causes of action. The implication to our world is no doubt on the FCC Enforcement Bureau's ability to enforce the Communications Act and the FCC's rules through administrative enforcement proceedings without bringing an action in federal district court.
Okay, so obviously we're faced with some new questions as to how agencies will issue decisions and how courts will evaluate those decisions moving forward. So let's turn now to the impacts in the telecom space. My takeaway from the SEC v. Jarkizi case is that agencies will be increasingly limited in their ability to enforce their rules and regulations without filing lawsuits. Where do you think this leaves the FCC's Enforcement Bureau?
Unclear. The Enforcement Bureau's authority might be preserved by the fact that the Jarkizi court clarified that administrative tribunals are acceptable for adjudicating public rights, which might be construed to include FCC licenses and other privileges granted by the Communications Act. On the other hand, a persuasive argument could be made that the FCC's enforcement authority is grounded in common law. For better or for worse, the contours of the FCC enforcement powers will become clear when one of the many well-counseled entities that are currently regulated by the FCC challenge an Enforcement Bureau order. Flipping it back to you, Sarah, what do you anticipate happening at the FCC as a result of the elimination of Chevron deference?
Well, first, I think there will certainly be more challenges filed in response to FCC rulings and decisions than ever before. So, in the Chevron era, parties that were harmed or otherwise obligated to do something that they didn't really want to do by an FCC decision would need to heavily consider the likelihood of success and the time and cost of filing a court challenge. And this assessment now faces an updated calculation because that likelihood of success factor of those challenging agency actions definitely increased. So, where an ISP or a telecom carrier doesn't like an FCC ruling, it can argue that the agency doesn't have the specified authority to make that ruling in the first place.
Yeah, I think we're going to see a rush of lawsuits filed against the FCC as well as other federal agencies. So there's going to be a big slowdown. Our court systems aren't the speediest as it is, and litigation is a lengthy process. And given this decision, courts might place temporary holds on making FCC decisions effective while litigation plays out. So even if the FCC does have authority for the ruling at issue, its implementation might be stalled for months, if not years, until the litigation is resolved.
Oh, I think you're absolutely right. Prolonged uncertainty and increased disputes. Things will look very different at our federal agencies going forward in light of these two decisions, especially the FCC. All right, Steve, thank you so much for joining me to talk about this today.
Absolutely. Thanks for having me.
And if you are interested in getting further into the weeds or discussing the intricacies of FCC decision making and adjudication, please drop Steve, me, or any of our LB3 or TC2 colleagues an email or give us a call. And finally, you can always stay up to date by subscribing to these podcasts, by checking out our websites, and by following us on LinkedIn.